Good morning. Thank you for coming. I'm pleased to have been asked to join in this conversation about voting. I have had a concern about voting rights virtually all my life, going back some years. And certainly while I was in college, I was very much involved, engaged in efforts to expand voting opportunities for persons who were facing roadblocks of one kind or another. I have been very much concerned about developments in recent years because these developments that are underway are catching a lot of people off guard. They seem to be very benign to the point that persons who are really going to be victimized by the proposed changes shrug their shoulders and say, oh, well, no, I don't see anything wrong with that. If it's photo ID, I have to show my ID if I want to buy a pack of cigarettes, or if I want to buy a drink in a bar, or if I want to buy some beer. If I want to board a plane to go hither and yon, I have to show some ID, so there's nothing wrong with that. So why should I not show ID if I want to cast a vote? There's one problem with that. There's nothing in the Constitution that guarantees anybody the right to buy cigarettes or to buy beer. Those aren't constitutional rights. There's nothing in the Constitution that provides right for a person to board a plane without showing ID. However, when we come to the vote, we have the 15th Amendment, and we also have the 14th Amendment as well. Those constitutional rights are enshrined in our basic documents that guarantee to every person the right to vote unfettered. And when those rights were made a part of the Constitution, they were extended to persons who had been slaves. Persons who the Supreme Court had said in 1857, in the famous case of Dred Scott, that they were not citizens, they were not human beings, and therefore had no rights that white people were bound to respect. And that led President Lincoln to issue the Emancipation Proclamation to ensure that the newly freed slaves, or slaves at that time that he was emancipating, would have all the rights of citizenship. But the Dred Scott decision was an impediment. And in that decision by Justice Roger Taney, he said in 21 different places in his opinion that black people were subhuman. They were of an inferior order. And so it took an amendment to the Constitution 3 times. The 13th Amendment that declared that all persons born or naturalized in this country were citizens. The 14th Amendment that said no state can deny to a citizen due process of law. No state can deny equal protection of the laws to a person based on color or race. And the 15th Amendment guaranteed the right to vote. And this right extends to every American, every person born or is a citizen of this country. And so to counter those amendments, the various states in the South began to devise various schemes and artifices to interfere with the right of the newly freed slaves to exercise their constitutional rights at the ballot. They were very creative. They came up with, they used violence for one thing. We had the Klan and the White Camellias and all these different organizations to intimidate the former slaves from voting. And when that didn't work, and they took control of they shied people withheld their vote. The people didn't go to vote when they had a right to. The state legislatures were taken over by the people who had been in control prior to the Civil War, the segregationists, the states' rights persons. And they proposed a number of tripwires and artifices to keep the vote away from the former slaves, such as literacy tests. Oklahoma in 1910 passed a statute that said that a person, in order to vote, had to be able to read and write, except if your grandfather voted prior to 1866. Well, the ex-slaves could not vote prior to 1866, nor could their grandfathers. So that was a way of excluding people. That was a way of coming up with a scheme that had the effect of, and the word effect is very important. If programs and policies will have the effect, even though they seem to be they seem to be benign, but the Supreme Court has consistently struck them down, and the Supreme Court struck down the Oklahoma law because it said it had the effect of denying, even though the word black, slaves, those words were nowhere in the statute. The court said the act itself had the effect of discriminating. And consistently, the Supreme Court has taken these different programs and examined them and held that they were unconstitutional. The literacy tests, the white primary. Those of you who are covering politics today probably don't know what the white primary was or how ridiculous it was. But it was, white primary grew out of a declaration by the Democrats that their primaries were conducted by a private party. The Democratic Party was a private party, and as such, a private party can decide who it admits as a member. And so the primaries were conducted exclusively by and for white people to get their candidate for the general election. So it was preordained. Oh yeah, they can come in and vote in the general election, but the decision as to who the candidate would be was determined in the primary, for which blacks were excluded. The Supreme Court struck that down after many years of litigation. And I'm glad to say that my predecessors, prior to my joining the court, I served 23 years on the 6th Circuit Court of Appeals, but prior to that time, I was general counsel of the NAACP. I succeeded Thurgood Marshall and Charles Houston and Robert Carter. I was the 4th general counsel. But those 3 predecessors were the ones who litigated the white primary cases in Texas. It took years before the Supreme Court reached the point of striking down the primaries in Texas and Louisiana.